If y'all want to, come pick one up and pass it around, go ahead and get registered for that silent auction by downloading that QR code. Would also like to call your attention to these panels on each side of the stage. They list the sponsors for this conference. We're very thankful for sponsorship, and each of those panels denote which level of sponsorship that they have chosen. Our next panel is called the Judges Carousel. It's going to be led by Mike Fish. We're very honored to have three judges with us today. Mike Fish is a founding member of the Birmingham insurance defense firm Fish, Nelson, and Holden. He obtained his BA degree from the University of Georgia and his JD from Cumberland Law School right here at Sanford, where he was one of only 8 students selected by the faculty for the academic honor of Order of Barristers. Fish is a past chair of the American Bar Association Workers' Comp and Employers Liability Committee and the immediate past president of the National Workers' Compensation Defense Network. Most recently, Fish was inducted into the prestigious College of Workers' Compensation Lawyers. He is honored as an attorney who has distinguished themselves in the practice of the field of workers' compensation. This is Mike Fish. And now let me introduce our judges. Our first judge here to my left is Judge Scott Powell. He served as a Jefferson County Circuit Judge for 18 years. 10 of those as Jefferson County's presiding circuit judge. Judge Powell also was a member of the Alabama Court of the Judiciary in 2003 that voted unanimously to remove then Chief Justice Roy Moore from the office for refusing a federal court to obtain and remove the 10 Commandments monument from the state. Upon retiring from the bench, Judge Powell formed Powell and Associates, a mediation, arbitration, and private judging practice. To my immediate right is Judge Jeremy Taylor, who graduated from law school at the University of Alabama in 2005, where he was a member of the Alabama Law Review. He worked in the law firm of Busman and Taylor in Fort Payne until 2007, where he became an assistant district attorney for the 9th Judicial Circuit. He serves as a member of the Judicial Inquiry Commission, a member of the Alabama Civil Pattern Jury Instructions Committee on the Supreme Court's Access to Justice Committee, the Domestic Violence Court Advisory Committee, the Technology Committee, and is a member of the Board of Directors and the Educational Committee with the Circuit Judges Association. Judge Jeremy Taylor. And last but certainly not least, Judge John England began practicing law in Tuscaloosa in 1974. He was appointed by Governor Jim Folsom to the Tuscaloosa County Circuit Court in 1993 and elected to a full term in November of '94. He served in that capacity until he was appointed by Governor Don Siegelman to the Alabama Supreme Court in 1999. Judge England served on the Alabama Supreme Court from September until he returned to the Circuit Court of Tuscaloosa County in 2001 and served until his retirement in January of 21. Please welcome this panel. Thank you.
Thank you, Henry. Well, I think we left a few minutes for our presentation. You got to expect a lot of introductions when you've got a panel like this. I guess we've been doing the judge panels for a few years now. It's always a lot of fun. This is the first time that we've ever included retired judges on the panel. And we've certainly not had 56 years of combined judicial bench experience on our panel. So I've been excited to moderate this panel. I think the judges kept asking me what I was going to ask them, and I really just hadn't decided yet. So they're going to find out what I'm asking them as you find out what I'm going to ask them. But certainly they're better on their feet than anybody. So with that, I'd just like to tell you, so I'm not going to introduce them, that was just done. I would like to say that I have experience in front of all these judges. Probably, well, Judge Val took the bench in '94, so I graduated from law school in '95. So I've tried many cases, jury trials, bench trials in front of Judge Val. I always tell people my first jury trial, my claim to fame is I got a defense verdict, my very first jury trial in front of Judge Val. And hopefully they won't ask which side I was on because I was a plaintiff's lawyer my first year. Judge Jeremy Taylor, the first time that I was live in court after the pandemic, once they started to release the rules a little bit and let people come back into court, I had a summary judgment that I had to argue, and Judge Taylor had us come in live in court, and I had not had to deal with the mask and my glasses. And so I got in there and he said, we'll start out, Mr. Fish, arguing your motion for summary judgment. I said, well, Judge, the first thing I'm going to have to decide is, do I want to not see with my glasses on or not see with my glasses off? He graciously let me take my mask off. And then one thing that I wanted to mention that wasn't in the bio that Judge England provided us, but I think it's very worthy of mentioning, is that he was in the very first University of Alabama Law School class that had Black students, the very first one. And one of his, I think, greatest honors is that all three of his children have since graduated from the University of Alabama Law School. And his namesake, in fact, is a federal court magistrate judge in the Northern District to this day. So I just wanted to throw that out there. So, so this is going to be loose. Like I said, the judges don't know what I'm going to ask them. Also, we invite audience participation. So if there's anything that we haven't addressed, or if you have a follow-up question and you want to know how the judge feels, either currently or how they would have handled something when they were still on the bench, or how they wish they would have handled it, certainly raise your hand and then I'll come to you, or you can shout your question and just let me repeat the question so everyone can hear it before they answer your question. But no rules today. We've still got 45 minutes to do this. So just to get things started out, just a fun topic is we have a question and answer microphone. Now we just need a question and answer person to run the microphone to people. If Josh Holden is out there, will somebody grab Josh Holden? So surveillance. So, organization like this, we have surveillance vendors, and we're always, in the questionable claims, we're always trying to send those surveillance investigators out there to get that good surveillance. And, you just got to get them on the right day. But every once in a while, you get some really good surveillance. And I know the really good surveillance probably doesn't see the inside of a courtroom because we probably settle those cases. But just for fun, Judge Val, does any workers' comp case stick out in your mind where the defendant played some surveillance video that you thought was particularly effective, or maybe it wasn't as effective as they thought it was going to be?
Well, the one I can think of that I still wake up in the middle of the night laughing about was a plaintiff preacher who came into my courtroom on a walker, surrounded by his supporters. He could hardly get to the table to sit down. And he sat down, and the videotape came in after his testimony. And there he was preaching with white patent leather shoes on, and he kicked those shoes up higher than his head and did it for some length of time. That was the end of his lawsuit. The only problem with visual evidence like that is it doesn't give the lawyer a whole lot of room to argue. when you see it and it becomes quite clear that this is a fake deal, there's just not much else you can do about it.
Right. There's not too many claimants out there with identical twins either, are there?
Not,
What about you, Judge Taylor? Have you had any that stick out in your mind?
Yes, I had a self-employed contractor who had taken a lot of money to do some home improvements and then didn't do any of them. And so he was charged and convicted. And as part of his sentence, he was ordered to pay a lot of restitution. And he had to then get a job, which he did at a timber company, and got hurt within just a few months. And so he's hurt, he's out drawing benefits, he is on probation and not paying his restitution as he had agreed to. And so actually the video was presented from the workers' comp defense investigator to the state. And so I actually saw the video in the context of a probation revocation hearing in which the state had alleged that he should be put in prison or put in jail for violating probation for working and not paying. And of course, at that point, I had tens and tens of thousands of dollars worth of restitution that he was supposed to pay, a pending workers' comp case in which everybody was hoping would settle and would end up in a payment of his restitution and his criminal fees from that money. And it left me in a bit of a quandary because if I revoked his probation for not paying while he had the ability to pay, then I would have probably sunk the workers' comp claim, because then he was working. And so it presented me with quite a problem until he committed DUI about a week later, and I was able to put him in jail for that rather than not paying. So it was effective. It just left me in that case in a pretty hard spot. The case wound up resolving. I would love to know why and how, but I don't. But it ended up resolving with some settlement, and the restitution got paid. But it was, as Judge Val says, it didn't leave a whole lot to argue.
Well, it's nice of that guy to help you out with your quandary. You don't get
He
that
did.
very often, do you?
Well, I thought it was interesting, though, that, that the lawyers and the investigators were certainly on top of the defendant's, the criminal defendant situation, the workers' comp plaintiff situation, enough to say, we know this is going on. We're going to provide this to the state and see what happens. And actually, I believe the workers' comp lawyers were there for the probation revocation hearing, which was unique.
What about you, Judge England? Anything stick out in your mind?
Well, I had a few of them, but what sticks out in my mind is on a couple of occasions, it depended on what time in the morning the worker was filmed. Because if it's a certain time in the morning, he appeared to be, as he testified, in pain, stiff. Then late on the afternoon, he could carry trash to the dumpster. So depending upon, and of course, those who did the filming, I'm sure they wanted to get all of the film they could get that would support whatever claim they were making or whatever defense. And for me, what I remember more than anything else was the debate between the lawyers over whether or not the possessor of the film had a duty to disclose it to the plaintiff in light of the plaintiff asking for, that kind of discovery information. So, depending upon the situation, whether or not the lawyer had on an Alabama tie or Auburn tie, I'm just kidding, of course. I'd make the decision. I always felt that disclosure was the best practice. But, I always got and you're a good defense lawyer, I always got, well, Judge, I'm only going to use this for impeachment. Consequently, I have no obligation to give him that. So that's my experience with that particular issue.
And isn't it strange how all the medical providers, when, I don't know, the surveillance I've seen, it seems like the driveway, the pavement is always, it needs a lot of work in front of the medical providers buildings versus like the local grocery store or the Burger King where it's easier for them to walk. I don't know if you've noticed that. They probably need to work on that. Moving on to doctors' opinions. So obviously, the workers' comp system, we deal with surveillance. We also deal with a lot of a lot of doctors, and doctors are called upon to offer opinions. Sometimes it's opinions on causation. Sometimes it's opinions on when the claimant reaches maximum medical improvement. Sometimes it's, whether or not they have permanent restrictions. These are all important variables in the workers' comp equation. Have you ever felt it was your duty? It's time, let's start with you, Judge Taylor. Have you ever felt like as the judge that you needed to step in and give a different opinion than what the doctor was offering for whatever reason? Maybe because there was other evidence that the doctor wasn't aware of, where you said, all right, the medical provider is saying there are these restrictions, but I've seen something else. And so I'm going to say, as the judge, I'm going to say he has no restrictions. Have you ever done that?
That he has no restrictions.
Right. Or different restrictions.
Yes. I'm trying to recall a specific case. I don't know that I can give you the facts of it readily, but yes, I have had testimony that, that I believed from a plaintiff that just, what they can and couldn't do. And it was different than what the doctor said. And so to answer the question, not without being able to give you an example, yes.
Okay. Judge England, have you ever found yourself at odds with the doctor involved in a case, the authorized doctor, and as far as your opinion versus the doctor's opinion on an issue?
Yes. Does that answer the question?
It does, in fact, answer the question fully and completely.
I can add one more thing.
Please
One
do.
more thing.
Please do.
Certain doctors are called by plaintiffs or defendants. And it seems that those doctors will give the same opinion for plaintiffs. And so when I hear or the same opinion with respect to defendants or claimants, and so I look at that and I say, well, did they simply hire him or her for a specific opinion? And do I need to be looking myself? Because most of the time, I'm not surprised. Well, you probably know I'm from Tuscaloosa, and so there are some lawyers who do quite a bit of workers' comp, plaintiff and defense. And there's a certain doctor who seems to always be called when there's a pain claim, pain claim to exceed scheduled injury. And so when you hear the same doctor always giving that, you're going to have some questions about it. So that's the conclusion of my answer to that question.
Judge, I heard about a doctor who would testify that a knee replacement is never totally workers' comp.
I heard that in this room.
Every time. Kind of what you're talking about.
Is that lawyer here?
Fred, are you in here? Fred, if you show up in Judge Taylor's court with a knee doctor, you might have some splaining to do.
Mike told me to say that.
Judge Val, have you kind of building on what Judge England just said? Do you remember anything come to mind, specific doctors where you'd see the same doctors pop up time and time again?
Absolutely. Even with a medical center as Birmingham is, with all the hundreds of well-qualified doctors that we have practicing here, we soon learn which ones are going to always testify that there is no permanent injury, and which ones will always testify that they're 100% disabled. And frankly, those people who fall into those categories have lost all credibility with the judge, certainly with me. And I have even gone to the extent of writing in a final order that the testimony of this doctor is not entitled to any credence in this court.
I remember it well. It was not my case, but I remember the order.
It could have been.
It was a very well circulated order, let's put it that way. But credibility is the key, isn't it? I mean, when it comes down to it, if you're being asked, if any of you are being asked to decide something, whether it's the opinions of the doctors or the opinions of the claimant or the plaintiff, even the lawyers that are making the arguments to you, once they lose credibility in front of you, how do you get that back? That's hard to get back, isn't it?
It's damn hard to get back.
Right, right.
I mean, once you've lost confidence in in a lawyer's fairness, it's almost impossible to forget that in the future.
Sure, and that trickles all the way down to the beginning of the case with the employers and with the adjusters. If you've got cases where it's something happens and all of a sudden there's a tort case associated with, and all of a sudden the claims notes possibly become discoverable. It's always remember, if you're doing the right thing and you're maintaining your credibility, you may not get the outcome you want, but you'll get hopefully the right outcome, right?
Right. Yeah, no case is important enough to make a lawyer lose his credibility with the judge.
Right. Judge England, let me start with you this time. So as you know, in the workers' comp system, the employer, at least in Alabama, the employer has the right to direct medical care. And as part of that right, the employer chooses the doctor initially. The adjuster has a duty of due diligence. They have to make sure that the procedures that the doctor's recommending are medically necessary, that they're causally related, that they're, that the cost is feasible or necessary. And there's procedures they have to go through. There's hoops they have to jump through, utilization review process. Sometimes the length of time is outside the adjuster's control. Have you ever penalized an employer or the adjuster or anyone on that side of the fence because the process was taking too long?
I have not. I have threatened to, but I have not. And I've discovered that the threat is enough. And I'm retired, so I'll never do it.
Now that you're retired, do you look back and wish you'd done anything differently along those lines?
There were a couple of occasions when something occurs and you understand that an attorney has a client and he wants to be viewed favorably by his client, but he really doesn't deserve it. On those occasions, I have told the lawyer to come into my chambers, and I told him, unless you stop, I'm going to, in open court, say what you have done that the court disapproves of. There's one person I think maybe I shouldn't have done that. I think I should have gone ahead on and said in open court that this is unacceptable conduct for an attorney. So that one time, and I'm not going to give any more information along those lines than I just gave.
Was that a workers' comp case?
Part of it was.
Okay.
And you were not in.
Judge Val, I'm not going to ask you the same question. But
Why not? I mean, you asked. Give me a break. Come on now, ask him that.
You get
Judge
the-
Val gave me $10 and said, give me the easy ones. But your answer, Judge England, made me think of something that I would like to ask Judge Val. And that's this, the Alabama Workers' Comp Act for the plaintiff's attorney to represent an employee in your court or any court, they have to get your permission. They have to file a petition to approve their attorney for work in the Alabama Workers' Comp Act. So that's not the same on the defense side. They can hire whoever they want on the defense side, but these petitions are filed just automatically when the summons and complaint is filed, the petitions are filed, and then it seems like it's a rubber stamp. I've never seen one denied, let's put it that way. And Judge Val, when you got those petitions, is it in fact a rubber stamp, or would you look at it and say, I've never heard of this attorney. I need to find out more about this attorney, or going along with what Judge England said, I do know this attorney and this attorney has no business handling workers' comp cases in my court.
Well, you certainly form opinions about who's competent and who's not. But I don't believe I have ever refused to grant a petition to represent a plaintiff. I think that can be a dangerous thing, because I think an injured party has a right to select the attorney of his choice, as long as he's licensed to practice.
Okay. And so as a follow-up question to that, if you have approved the attorney and that attorney is representing the plaintiff and the defense lawyer and the plaintiff's attorney have arrived at a settlement, and I know this is in your past, but they do arrive at a settlement that closes medical benefits. That's getting court. That is the same look. You have approved this attorney as someone that should be able to look out for the best interest of this claimant, right?
Correct.
So I understand that the statute requires you to also have a best interest hearing. Under what circumstances would you feel that your idea of the best interest for the claimant is not better, but different in what's going to be the way it goes versus what the plaintiff's attorney thinks the best interest of his client is?
Well, the cost of medical treatment in the future is obviously the most important thing to the employer, because that's where the real money can come back to them. I think that a lot of times lawyers in a particular case will be so tired of litigating it that they're just ready to reach an agreement and say, okay, we'll close future medicals, add another $15,000 to the lump sum, and we'll go home. So I think that a judge has an obligation to weigh all of those things, known and unknown, as well as the reputation of the lawyers. And there were cases that I approved closing future medicals. Very few, but
All mine.
well, you shouldn't have brought them.
Just remember the look that you just saw from Judge Bowell. I'll never forget the day I went in there. It's right when Medicare set-asides, we started using those, and I went in there and he said, Michael, tell me you're not trying to close medical benefits. And I said, Judge, I'm not trying to close medical benefits. I'm just shifting responsibility for paying medical benefits. They're still open. And I got that same look. We had a question, Josh. Too late. So the question is, would a Medicare, so are you saying like, if there's if an MSA isn't necessarily needed, but so you just instead get a medical cost projection, which is another type of version of that, but we're not worried about whether Medicare cares about it. So let's move on to Judge Taylor for this question. Judge Taylor, if you have a situation where you don't necessarily have to consider Medicare's interests, but you're closing medical, and just to get a pinpoint a number, that you think is reasonable for medical closure, you get a medical cost projection from a vendor. Does that influence your decision on whether to close medical benefits?
Absolutely. It would. And also in those cases in which medicals have been left open and they come back and want to close them. I often see those, the second, where medicals that have been left open are now coming back for a petition to close and a settlement with unrepresented claimants. And I almost universally have seen those go south when they get in the courtroom, because usually the testimony winds up going something along the lines of, they offered me $15,000 and my car's broke, I need that, so this is what we're doing. And that doesn't make me feel good about things at all. Of course, having a projection, as you talk about, would help a great deal, especially in those kind of cases. I assume if medicals are being closed and there is a plaintiff's lawyer involved, that some version of that estimate has been talked about and considered, and a cost benefit analysis, is done in some way, before they walk in there. But certainly with unrepresented litigants, I have probably denied more of those than approved for that very reason. It just doesn't, the numbers just don't seem to make sense to me as best I can understand it. And if somebody laid that out for me, it would make more sense.
Okay.
Those are really, really hard decisions for a judge. And the client often knows more about his financial situation and about the threats that he's faced from litigation or his other personal problems than a judge could ever know. So it's a very serious thing when you substitute your own judgment for that of an unrepresented plaintiff.
And it's a little bit like having something like that. I can analogize a little bit to the cases in which someone is trying to basically buy structured settlement. The statute is very detailed in what we have to have in order to approve that, including charts and amortization and all these things. And it really, you can't hide numbers there. And so it's helpful for us to see that and to know, because those are universally unrepresented litigants. So to analogize it to a point where it is absolutely required versus in this situation where it isn't, it would be helpful, because it is helpful in those cases.
Judge England, let me ask you a little bit different question, but along those same lines. One situation where you don't have to involve a Medicare set aside, even if the amount of the settlement would reach the threshold numbers where you're looking at, a Medicare set aside probably should be involved. One exception is if it's a disputed claim, legitimately disputed claim. If it's a completely disputed claim, settle it as a compromised lump sum settlement and not involve Medicare, not allocate any amount specifically towards medical. It's just, hey, the defense is saying, we're saying we would have won if we went to trial. Did you ever have any of those in front of you where you thought they're saying that it's disputed, but they're just trying to get around Medicare? Can you think of anything that just kind of pops into your head and why maybe you didn't approve it?
I'm waiting for something to pop into my head.
My experience, Judge, is that usually if we could do that, there's something we can point to. So I guess, the question is, how much evidence would you require as the judge deciding whether a settlement should be approved or not? How much evidence should we have to prove that it's legitimately a disputed, potentially winnable case from the defense side?
Well, I don't know how y'all do it in North Alabama, how y'all do it in Jefferson County, but in Tuscaloosa, we have workers' comp days set aside where we have the worker, his lawyer for the defense to come and present the case. What I always did was, if someone's represented by counsel, then when I say someone, I mean the employee is represented by counsel. I'm going to listen very closely to that. And I'm going to follow that most of the time, unless it's pretty obvious. Now, where the problem comes in at is when they're unrepresented. And then even when you're talking about closing medicals, the question I always ask that unrepresented litigant is, okay, if 2 years from now, you've got to have a procedure, how you gonna pay for it? Most of the time, they don't know. And that when they say they don't know, I said, you want to close the medicals? Now, of course, I know you don't want me to say that because you spent all that time getting that case resolved. And here I come up here messing it up. But I think that's my obligation to inquire. Many pro se litigants say, I worry about that then, but I need it now. And don't stop me from letting me have it. Well, in those situations, I do. But I've just learned over the years that, as a general rule, very few of those cases where there's any real dispute about what actually happened, such that there's a real question about liability. Heck, too often someone will say, the cost of defense is $2,000. Hey, you can have $1,500 to resolve it, and usually that means there's not much merit to it other than the head of the worker.
Right. Yep. No, you have the workers' comp days. Are there any Tuscaloosa plaintiffs' attorneys in the audience?
They would not say it if they were here. They wouldn't let me know that I see it.
I was just going to say, you called it a workers' comp day. I call it day that Steve Forrest shows up with a bus of clients. They literally line the halls just waiting for their turn. Judge Val, in 2003, you were on the bench. You're the presiding judge. You were the presiding judge. When did you assume the role of presiding judge?
03 through 13.
Okay. Well, I guess maybe then one of his first official acts was he formed a workers' comp committee. And the reason I'm bringing that up is two reasons. I was on the committee. It's a good reason. Number two, the reason for the committee was that, HIPAA just we were starting to deal with the HIPAA stuff. So we were dealing with that, but also Judge Val recognized a problem with the system, in that the judges that were called upon to determine whether or not a settlement was in the best interests of the claimant were then the same judges that were eventually going to try and hear the case and decide the case. So on one hand, they're deciding that this settlement is not in the best interest. And then later on down the line, they're called upon to be fair and impartial, whereas and here they're kind of you're siding with the claimant. And so as part of that committee, you came up with a local rule that if the judge that presides over the best interest hearing determines that the settlement is not approved, then that case automatically got kicked to another judge to be determined or for the trial itself. That's no longer a rule in Jefferson County, by the way.
I understand they have that. When I went, so did my rule.
It did.
But I thought it was a good idea in that as presiding judge, I handled all the best interest hearings. So if I rejected a proposed settlement or a closing of future medicals, I would send that file back to the clerk's office, and there the AOC would reassign it to one of the other judges so that they could have a fresh eye for it. And sometimes they would actually reverse my conclusions, but the statute is so peculiar in that it requires that the presiding judge or that the judge have a hearing and make a determination that the proposed settlement is in the best interest of the plaintiff, which to me is something different from saying you need to listen to the evidence and decide the truth. it almost puts the judge in the position of being an advocate for the injured plaintiff. And I think that's an aspect of that that needs to be changed.
Right. So in Jefferson County, obviously they've got enough judges where if that did become a rule, or if it became law, it was part of the workers' comp statute, that would be easily implemented. Of course, we have some counties where there's just one judge, so I don't know how they would,
Yeah, I don't know how that would.
how they
work.
would resolve that. Judge Taylor, have you run into that issue? And if so, how do you resolve that issue?
Well, one of the unique things, I guess, about being a judge versus when I was a lawyer is I don't practice in anybody else's courtroom. And that sounds obvious, but when you think about it, I don't get a chance to experience these kind of initiatives. It's the first I've heard of this. I like that idea. We have 3 circuit judges in my circuit. And I think even in something as small, a circuit as small as ours, that is something that we could talk about. And so I don't think that's a bad idea at all. And I certainly agree with Judge Vowell that it does put us in an interesting position that we're not used to in approving these claims. And so, but as he says, also, there are plenty of circuits where, they don't even have the benefit of having 3 of us. So I haven't seen that. I will say, I don't know that I've experienced a lot of consternation after looking at a case a second time. But to avoid, I'm putting on my Judicial Inquiry Commission hat, to avoid even any kind of appearance issue, I think that's a good idea.
Okay. And so in Tuscaloosa, as you've already, I almost said testified, as you've already said, Judge England, that the way you handle settlements kind of takes care of that issue, because you just have one particular judge handling all of them that day. So there's a good likelihood another judge probably has that case to handle discovery and trial anyway, right?
Sort of. Because actually we rotated.
Okay.
So that means that this month, Judge Pruitt, and I mentioned his name because that's who replaced me. Good judge. Y'all, if y'all see him, y'all tell him. England said you're a good judge. I had to retire because I got too old. I know none of you believe that, right? Right. The thing is, though, what we do is that we handle the cases that are assigned to us, and then the cases that are assigned to all the other judges. And I was interested in Judge Vowell, your comments, because we get a lot of them. We call them Birmingham lawyers. I don't know what y'all call them. We get a lot of Birmingham lawyers who bring their cases to Tuscaloosa. And the reason why they do it is because we do this regularly on a monthly basis. So they get their cases resolved.
And also because Vowell wouldn't approve the settlement.
It couldn't be, but the point is that that's not been an issue that has been raised in Tuscaloosa. The possibility of a appearance of unfairness or whatever, because you reject the settlement, because many times the settlement may be rejected because the employee realizes, well, I don't want to close the medicals. So we just haven't dealt with that. We've continued to do it that way, and it seems to work. And has not been a problem. Although I'll admit that, you're dealing with 3 other judges' cases, because there are 4 judges who handle workers' comp in Tuscaloosa. And so it's just a 1 in 4 opportunity that it'll come up.
Okay.
And contrary, for our circuit, once a case is assigned, that judge has that case till it's over. And so that is a different experience with us, is if we were to reject it, we would keep it, the settlement. So that is different in a smaller circuit.
Okay. So COVID-19, it changed a lot of the way we do things in workers' comp and every aspect of our lives. But one thing that has carried over, and I know we're still dealing with it, but things have opened back up. One thing that's carried over is that the Alabama Supreme Court, and I'm going to stay with you, Judge England, since you were on the Alabama Supreme Court. You didn't do this, but I'll ask you because of that. There was an emergency rule from the Alabama Supreme Court that said basically, even though it's a filed case, even though, one of these judges has jurisdiction over the case, if you want to settle, you can do so in front of an ombudsman. An ombudsman, by the way, does not have a statutory duty to find that the settlement is in the best interest like a judge would. But an ombudsman will basically make sure that the parties know what they're doing. They understand what they're doing, make sure their questions are answered, and they'll sign off on it. They don't have to genuinely believe that it's in anyone's best interest. And so what the Supreme Court says, you can have an ombudsman sign off on it. And then when you file a motion to dismiss the lawsuit that's already pending, the judge has to dismiss it. That was not the case before this emergency rule. Before, if you did that, chances are the case would not be dismissed. Now, there were some counties, I know down in the Mobile area, we were doing that, but the judges knew we were doing it. We weren't trying to circumvent the judges. The judges knew we were doing that, and some of them were okay with that. But here the Supreme Court said, judges, if they do that, you have to dismiss it. And they were a temporary rule until December, early December of last year, when that rule became permanent. Judge England, how do you feel about a rule? First of all, do you think the Alabama Supreme Court, if that's a rule that should be made permanent by the Supreme Court, do you think that, or do you think that the circuit court judges should retain that right?
Well, I think the circuit court judges should retain that right. But I'll also say this, and I learned this during the time I spent on the Supreme Court. We don't have enough. Now don't tell anybody I said this, but we don't have enough Supreme Court justices who've ever spent any time in court, with trial experience, and that's problematic. But don't tell them I said that. We're getting more, but I would say it should stay with the circuit judge.
Okay.
And what we know about those settlements is lawyers in Tuscaloosa still brought the settlement for the circuit judges to approve it. So I just think it should be left with it. That's my answer. I'm sticking to it.
What about you, Judge Val? I know we talked a little bit about this before we came up here. What are your feelings on a Supreme Court rule essentially trumping the workers' comp statute?
Well, I don't know that it's been tested yet. It was just adopted effective the end of December of last year. And I haven't seen any opinions addressing it, but I'm not so sure that even the Alabama Supreme Court can amend a statute by a rule. So
Right.
we'll just have to see how that.
Well, right. And talking before this, it hasn't been tested. And so the question is, well, who's going to test it? Because the plaintiff's bar entered into the settlement, the plaintiff's attorney entered into it willingly and knowingly and requested the ombudsman. So did the defense side. So the only one to test it would be the judge, right?
Well, I think one of the parties could change their minds later on and say, this is not valid because we did not get our hearing before a circuit judge. Couldn't that test it in that manner?
I suppose that's a possibility.
It would only happen if somebody later on is dissatisfied.
Right.
Yeah.
And I
Right.
think that's what it would turn on.
Right. And they'd have to give the money back.
But during COVID, we did a lot of stuff. I mean, when I say we, in the court system, we did a lot of stuff that was not authorized by statute. In fact, it was foreign to the statute. like criminal cases and how we handle that. And because of COVID, we were, these emergency orders were justified. Well, there's no longer COVID, so if somebody challenges it, they should lose it.
Well, I agree. Judge Taylor, let's talk about challenging. If you use an ombudsman, unlike with a judge, if you use a judge, one of the really good things about using a judge is you have automatic finality, right? Whereas with the ombudsman, they have 60 days to petition a judge to reopen the case and decide it. They're supposed to be able to show new information or fraud, those sort of things, but I actually haven't seen one reopen, but I always include language in my ombudsman settlement paperwork that says that they waive the right to petition the court in 60 days. And in exchange for waiving the right, we're giving them the money right away. And if they do challenge it, that we get our money back and they pay attorney's fees and all that sort of thing. What do you think about a provision like that? If somebody challenges a settlement and one of the defense attorney includes language in there that says they waive the 60-day right to appeal, how do you think you would handle that? Or has that come up?
I haven't seen it. Trying to analogize it though to other areas in which folks waive rights to appeal. I guess in the criminal context, in a plea agreement, when a person enters a plea, in a criminal case, they are waiving their right to an appeal. And I haven't seen it. And so I have not seen the issue in which someone then tried to come back and undo that, is what I mean. And
I don't think there's been a case on it.
Yeah, I haven't seen that personally either. And so
have any of you judges had anyone exercise their 60-day right to appeal a settlement that was not approved but signed off on by an ombudsman? I've not personally seen one in 30 years.
I haven't.
Have not. So it's just a rare beast, I guess.
That ombudsman program has really been a success, I think, for this whole scheme. And that it protects the injured worker and that somebody's there to be a spokesman in negotiating a settlement.
And it's free.
And it's free. It's free. At first, we had a problem in that it was so much in demand and there were so few ombudsmen that the delay was getting to be a problem. But I understand from what you've told me that's been remedied.
It has, and a lot of things are handled by phone now, and that's helped. We're handling the benefit review conferences with the ombudsman. Everything gets exchanged via email. The benefit review conference is done on a phone conference, so I can do the whole thing and never leave my office. So that's really expedited things, and that's another creature of the pandemic that's come from it. Things do move a lot quicker now.
Are there any of these ombudsman persons here? Because it seems now that I know what this organization is, there ought to be some.
There typically are some. They may not be in here. Anybody in here? No, so they typically are. They may not be right in here right now, but
Well, maybe we need to see if there was an ombudswoman.
Well, maybe they're settling cases.
ombuds person,
free.
Oh, yeah,
ombuds people. They're around. We've got good ones. We've got a lot of them now with legal experience. They're lawyers, former attorneys with workers' comp experience. We've got a few here in Birmingham, some in Mobile. And so that's helpful. And you mentioned it's free, and sometimes free is good. Sometimes
We don't turn down private mediation agreements, however.
that's where I was headed. That's where I was headed, Judge. Because one thing that wasn't mentioned specifically in the introductions, and Judge Val and Judge England do a lot of alternative dispute resolution. They both handle mediations. They're excellent. If you've got a lot of details that you need help with in a workers' comp settlement, or maybe problematic claimant that needs help, they don't understand the issues, and it would be helpful to have somebody formally on the bench. I think that carries a lot of weight and could be worth the money. They're definitely, with the experience that they bring, they're definitely worth the money in those situations. I'm mediating a case right now with a ton of parties with Judge England. In fact, we just met down in Selma, just so many parties. We just had to meet just to figure out who was involved in the case, didn't we? And then Judge Val does private judging, which my wife will tell you that's probably why we're getting a divorce. But tell everyone what private judging is, because I don't think people understand what it is. And I think if they did, they might use it more.
Well, I think it can be worthwhile. It hasn't really caught on yet. But if both sides of a civil suit agree, they can get a retired circuit judge to act as a circuit judge in that particular lawsuit. They file it in the circuit clerk. The clerk handles it just as any other civil litigation. But it can go at the pace that the parties want it to. If they have a case that has needs special expertise, they can hire a retired judge who has that expertise. And the glory of it is that you can get the case disposed of quickly and cheaply. And if you're not happy with the way the private judge rules, you have all the appellate rights that you would in any other civil litigation. So I think it's a good bet in the appropriate case. And I hope the bar will take advantage of it.
We've got 5 minutes. And since we have 5 minutes left, I just want to ask each of you the same question. So we haven't had much change in the Alabama Workers' Comp Act since 1992. That was the last time we had some pretty broad sweeping reforms. There have been some minor changes. We've had lots of attempts, but they usually get bogged down in committee. And, there's some things that universally, I think everyone believes need to be changed, like the extremely low, weekly maximum for permanent partial disability is the lowest nationally, I think. But if looking back, if you had a wish, if we have some reforms and we can get something done, Judge Val, we'll start with you and then we'll just work our way down to Judge England. We'll close with him. What would be at the top of your list if we could get some reforms? What would you want to see as a number one, or at least in your top 10?
Well, after listening to Clay and to the panelists that preceded us, I think it's pretty clear that we need to revise the way we select judges. They both said that the most important thing was who you drew as a judge. And that is not the way the system is supposed to work. We elect judges in Alabama, as you know, for 6-year terms. They're elected in partisan elections. They have to declare as a Democrat or Republican. And I just don't think it makes much sense to select judges based on their political beliefs rather than on their ability and fairness and experience.
Can't disagree with you there, Judge. Judge Taylor, how about you?
I don't have a lot to add to what you said because you hit on my issue. Those numbers just need to be higher. We don't need to be at the bottom of anything. And I am fully supportive of what you said about benefits.
Of the 220 max?
Yes.
Yeah. Yeah, it seems like every time that's put in front of a committee, it has so much attached to it that no one can agree on. Everyone could agree on that if that was the sole issue. It never is. Judge England, how about you? What would you like to see changed permanently?
Most employers are honorable people. Businesses are honorable businesses, but there are some who are not. And when you look at the cap for sometimes the most egregious conduct by an employer, they still get the benefit of the cap. When I say cap, I mean, even if it's a permanent total, when you compare that to the injury that's suffered, I think there ought to be some exceptions that would apply to employers who willfully allow their employees to be injured. So I think that ought to be looked at. Going back into the private world, when I tell individuals about what's the maximum they could get, if there's no third party they might be able to sue, that it's only going to be the employer, and we know that the employer's conduct directly caused it, I just think that should be looked at.
But that's the grand bargain, right? Exclusivity versus no fault insurance.
Right.
It works, it cuts both ways. doesn't it?
Well, that's a good point.
Well, why not give an injured worker the option to proceed with his common law action if there's been a breach of the standard of care? Or if there hasn't, if he can't prove any negligence, then let him fall back on the workers' comp statute.
Man, I'm against it, Judge.
I know you are.
I'm against it, just so everyone.
I got to say, though, that when you look at it, I'm not suggesting that simple negligence on the part of the employer. I'm not suggesting that at all. I think that's the balance. I'm saying we know when there's egregious actions taken, and so we need to separate it from that.
Some states do. I think some states do, and we're close to that with the co-employee, willful conduct of the co-employee, right?
That's right.
Right.
Okay, well, I think we're out of time unless someone just has an amazing question that's going to blow us all away. Anyone?
Did somebody?
I'm just kidding. I just want to see who'd look.
If anybody want to know that.
Amen.
Hey, how about these panelists, huh? Thank you, judges, for taking time out of your day. This was very, very educational. It's great to see some of my friends and